We now come to this fifth part, which I have dedicated to this additional layer of rules. Up to this point, we have looked at the main layer of rules, which pertains to the law in the fullest sense of the term. We have also touched upon the layer concerning ethical and deontological rules. We said that these are a somewhat particular, somewhat slippery aspect because they have to do with the behaviors, the habits of certain categories of people, rules that are mainly related to the management of a profession, of certain professions. Here, however, we have an additional layer of rules that concern everyone, but which have a different origin, a contractual origin. I'll show you in this slide a bit of trademarks of the main generative artificial intelligence systems used today, though this slide will probably become outdated soon and be replaced, because new AI systems are created every month, making it hard to keep up. Still, these are the most important and well-known ones, and I'm sure that anyone following this course of mine has an account on at least 1, 2, or 3 of these. Thank you. Of these generative artificial intelligence systems and uses them constantly. So, every time we use these systems, we are doing so in accordance with the rules established by the platform owner, by the service provider. And every time we signed up for the first time on these platforms, we were shown the classic screen with the terms of service and the requirement, the box to check to accept these terms of service. And we accepted them because otherwise we wouldn't be able to use this platform, the new platform. So what happens then? Here you have, in every respect, the terms of service, which are also called terms of use or terms and conditions depending on the case. These are in every sense the contract that governs the use of the online platform and therefore regulates the relationship between the service provider, that is the one who offers the platform, and the user of the platform. Is that clear? Each one has its own rules and it's not guaranteed that they're all aligned. In most cases, as we'll see when it comes to copyright, they're mostly aligned, fortunately. They've become aligned over time because when some of them first came out, they took slightly different paths, but now they've more or less come into alignment. The fact is, we should know these rules. If I were to do a survey right now and say, okay, raise your hand if you've read the terms of use of all these platforms from start to finish, I'm sure very few of you would do it, would raise your hand and say, yes, I have. Even I, as a lawyer who deals with these topics, I admit that I don't constantly read all the platform's terms either. Because we're in a hurry to use them, we don't want to wait, and we're not interested in knowing all the rules in detail, because we know that in the end, there's nothing we can do about it, we can't change them, we have no power to negotiate these rules. Okay, and if these terms of use contain all the rules for properly using the service, and there are a series of standard contents, for example, what is prohibited to do with the platform, usually there's a section that explains what you can and cannot do with the platform. In this section, there are also rules regarding copyright ownership and the use of someone else's copyrighted works. For example, if I upload an image that I found online and use it to do something, to have these generative AI systems do something, I need to make sure I have permission to use that image if it isn't mine, if I don't own the copyright, right? They usually also specify the applicable law and the jurisdiction, right? That is, which law applies in the event that a dispute arises regarding the interpretation of these terms of use. And why is this necessary? Because, almost always, since these are services offered via the internet, they are transnational, meaning they go beyond the borders of a single country. So each time we have to determine which law applies. I assure you it's not such a simple matter. Here, and almost all of them also specify the legal consequences we should expect if we do not comply with the rules established by the terms of service. From this point on, we will refer to the terms of service as TOS, which is clearer and shorter. As I was saying, the aspect of intellectual property is also regulated and managed within the TOS of generative artificial intelligence systems. So, more or less all, though not absolutely every single one, of the terms of service for generative artificial intelligence systems explicitly state that the user of the AI platform invariably retains complete ownership of the input, that is to say, whatever I personally provide, such as my specific prompt, or the initial draft text of my article that I genuinely want to have thoroughly reviewed and subsequently developed further. There is no doubt about that part. The ownership of the rights is left to me, the user. And then the service provider generally assigns the rights to the output to the user as well. So if I have a text to revise, for which I hold the rights, I provide it to ChatGPT. ChatGPT gives me its revised, developed, and improved version, and the terms of use of ChatGPT by OpenAI state that I also have the rights to the output, okay? Go read them. I'll show you the example later, the second part, let's say, of the slide. All the TOs of generative artificial intelligence systems specify two things. That the user remains responsible in any case for any intellectual property infringement. That is, ChatGPT, in the example we gave earlier, OpenAI, cannot know whether the text I am providing was actually written by me or if I took it from someone else without asking for permission. And so OpenAI says, I leave the responsibility to you. So if there is a copyright infringement later, we could take action against you. We could hold you responsible as the user because you were the one who provided that text. The other point is that the user must still guarantee that the input does not violate the rights of others. So, when I upload an image, text, or video to a platform like this, I am guaranteeing to OpenAI, Anthropic, and Google, depending on the case, that I am taking full responsibility from a copyright perspective. This is more or less what we find in all the copyright and intellectual property clauses of these terms of service. I've selected two for you, the most well-known and important ones, namely those from OpenAI, and the one from Cloud, and therefore Anthropic. As you can see, you can read it. Basically, here it explains what is considered under the definition of your content and distinguishes between input and output according to what we already mentioned earlier in the slide. There's no need to read everything in detail, but you can see that more or less the same things we discussed before are present here, namely that you are responsible for the content, including ensuring that it does not violate any applicable law or these terms. And then there's the part about ownership of the content, that is, the ownership of copyright over the content. You see, you retain your ownership rights in the input and also own the output. We hereby assign to you all our right, title, and interest, if any, in and to the output. OpenAI assigns to you, the user of the platform, every right over the output as well every right of use. We find something similar in the terms of use of Anthropic's Cloud. Even though the exact phrasing and presentation might be structured in a somewhat different manner, you can still clearly discern that there is a specific and important section that addresses the critical subject of responsibility within the document. In accordance with our established terms and conditions, so this is more or less precisely the same thing we've already seen and encountered in the previous text, and then also the specific section, as you can clearly see, on the ownership of rights, which is this final part, says you retain any right, title, and interest that you have in such inputs, so regarding the inputs, and subject to your compliance with our terms, meaning thank you. You still have to comply with what is written in these terms of use. So if you do comply, we assign to you all rights, title, and interest in the outputs. So basically the same thing, just worded differently, as you can see here. I assure you that in most of the other major platforms, something very similar happens. In conclusion, this is a final reflection, but it not only wraps up this last part, it also concludes our entire journey. So, what are we coming to say? That perhaps we need to rethink our concept of creativity, in the sense that this revolution has truly been explosive for copyright law and for the very idea of creativity. All creative professions must reinvent themselves, must rethink their own roles, including intellectual professions like engineers, lawyers, journalists, architects, and doctors, because everything that until now was considered undoubtedly human, of human origin, since refined intellectual and creative activity could only be human, is now very, very mixed and overlapped with the contribution of a machine. And so you see, we are facing a revolution that is even more impactful than a revolution that was already quite significant. the digital revolution, which we could roughly place at the beginning of the 2000s. Now, just 2 decades later, we are facing yet another evolution that could truly be even more important and historically more impactful because it touches on intellectual and creative aspects that until today were thought to be protected, untouchable, and yet have indeed been touched. For example, the very concept of creativity itself. I hope that this journey we've taken together has opened your mind a bit, clarified a number of doubts, and cleared away some of the urban legends that I'm sure you've come across in recent months and years. And now I hope you have a clearer idea and maybe even the desire to delve deeper into these topics. Because if you want to learn more, we've spent about an hour together in this online journey, but you can go much further and learn a lot more by reading my book, The Artificial Author, which is also available as open access. I truly trust that you'll certainly want to go even further, perhaps leave a thoughtful comment or a comprehensive review, write down some of your own personal thoughts and reflections on this important topic, and perhaps also share some valuable feedback on this entire training journey, letting us clearly know if you've learned something new and significant, if you genuinely want to go much deeper, or if you'd like more detailed information. I am readily available, and I sincerely hope you thoroughly appreciated my considered approach. Thank you. Here you have all the information, and if you search online, you'll find that I'm very active on the main social platforms, mainly Facebook and LinkedIn, YouTube, TikTok, and Instagram as well. Thanks again, and see you next time.